For those of you who don't know Curtis, he is a stalwart of the trial bar down here for maritime cases. Gets to trial at least a couple times a year. He's something to watch. He's great in the courtroom, super smart, great strategy guy. He's a mentor of mine, very fond of him, and I admire the work he does. So I'm pleased to have known him and to have learned from him. Curtis is a distinguished Miami-based attorney. He specializes in maritime and personal injury law for over 3 decades. He's renowned for his expertise in handling complex cases involving maritime injury, sexual assault, and liability for alcohol service. He has worked closely with the world's largest cruise lines, handling thousands of cases, many of which dealt with sexual assaults. Over the course of his career, Curtis has helped define maritime law as it is interpreted and applied today. And that's no exaggeration there. He has argued numerous appeals in both state and federal court, including the Florida Supreme Court.
You can start by counting over. What is this one?
All right. Sorry, someone was off mute. So over the course of his career, Curtis has helped define maritime law as it is interpreted and applied today. He's argued numerous appeals in state and federal court, including the Florida Supreme Court, and he has arbitrated cases across the world. His peers have rated him at the highest level of professional excellence, including an AV preeminent Martindale-Hubbell rating, and he is board certified by the Florida Bar, double board certified in civil trial and Admiralty, I believe. He has special knowledge, skills, and proficiency in various areas of law and professionalism and ethics in practice. So, Curtis, without further ado, I'll open the floor to you. If you need any help with your PowerPoint or whatever, let me know. But we're excited to hear from you. I know this is an area where you practice a lot, and you're very well versed in it.
Most of what I'm going to talk about today really is from the perspective of someone who represents the cruise lines and has for many years. But everything we're going to talk about is equally applicable to other types of situations, whether it be in a yacht, a charter, that kind of thing. So we'll start with talking about the basics. I know most everybody in this committee understands and knows this, but general maritime law obviously applies to cases that involve torts that occur in navigable waters, and sexual assaults are certainly no exception. Everybody knows general maritime law is sort of an amalgam of traditional common law rules, and that can be augmented or supplemented by state and federal law, but only to the extent that it doesn't conflict with it. There's a case in the state of Florida that came out back in 2000 called State versus Stepanski. It was a case in which the constitutionality of a Florida statute seeking to apply a Florida criminal statute to a cruise ship assault was deemed unconstitutional by the 5th District Court of Appeal. Stepanski's interesting only because the Florida Supreme Court reversed, found that statute constitutional, and it is used oftentimes by plaintiffs' attorneys who are bringing sexual assault claims and want to plead or allege Florida-based causes of action involving assault, sexual assault, which don't otherwise conflict with maritime law. So Stepanski basically held that a Florida statute that extended Florida's criminal statutes to ships that carry more than half of the revenue passengers embarking or debarking in Florida are subject to criminal statutes of Florida. The Stepanski case can be found at 761 Southern 2nd, 1027. And as I said, it's mostly used to try to bring in various state causes of action, state statutes. Federal law has got a number of statutes which are also oftentimes used to augment, general just strict liability claims for crew member assaults or negligence claims for passenger assaults. One of them right here is sexual abuse of a minor. And you can see, just looking at this, that you can plead a separate cause of action, and plaintiff's lawyers oftentimes do this for sexual abuse of a minor, which basically is anybody who knowingly engages in a sex act with another person who's 12 years old but not 16. In other words, a federal version of almost statutory rape, but it doesn't really necessarily require rising to that level. Any type of a sex act will be enough. And then it's got a little bit of an exception for people who are younger than that. Let's see, if you're 4 years younger than the person who's engaging and you're both not more than 15. All right. Anyway, there is a state of mind requirement here, but bottom line is that this statute is often used to allege a separate cause of action beyond just the assault itself. Another separate federal action we see sometimes is a sexual exploitation of minors act. And what's really relevant here is the subsection about producing a visual depiction involving the minor engaging in sexually explicit conduct. This often is where there's a videotape that's made of the individuals having sex, especially with a minor, and that gives rise to a separate cause of action. And there's another federal statute that actually provides for a $150,000 civil remedy for each violation of that statute that involves the videotaping of minors. And I've seen this pled where people have taken, 20 or 30 separate pictures, and there are 20 or 30 separate $150,000 fines that they seek. So it's kind of an interesting twist on what you see in your traditional sexual assault claims that are brought seeking the damages for the assault, emotional damages, and future damages, medical damages, and so forth, which is a way that I've seen some creative aggregating of damages. So I thought I'd just mention that at the start. When you talk about sexual assault, it's important to realize that the age of consent can vary. Maritime law has 16 years as the age of consent. But it's got sort of, I guess some people call this the Romeo and Juliet exception. If you're between 12 and 14 and your assailant is 4 years older, that's considered statutory rape under maritime law. But if it's 4 years or less, I guess you'd say, or under 4 years, then if there's consent by someone who's 12 to 14, that can be enough. Panamanian law, a lot of the vessels, cruise ships are flagged Panamanian. 18 years is the age of consent. 17 years or under is statutory rape. But again, you have sort of the Romeo and Juliet exception that's detailed there. Bahamian law, 16 years, just like federal, is the age of consent. And 15 or younger is statutory rape. And in Florida, it's 18, but you do have the Romeo and Juliet exception in Florida, which is described there. By and large, in most of these cases, maritime law applies. You will see some creativity sometimes on the ship's flag trying to argue that their age of consent should apply. And sometimes if the alleged assault occurs in a foreign port of call, for example, Mexico, you'll see them trying to argue that that age of consent should apply. And this is just generally either a plaintiff or defendant trying to get a little creative in either a defense of consent or an argument that a plaintiff could not consent based on the age. So it's certainly worth, being familiar with this and being familiar with those arguments. By and large, the courts have been pretty comfortable just sticking with the straight maritime law consent rules as it relates to incidents that occur on vessels that are in navigable waters when the assault is alleged to have occurred. All right. So maritime law splits sexual assaults into two pretty straightforward categories. Passengers assaulting either another passenger or crew member, pretty much a negligence standard, a negligence cause of action. Crew members, on the other hand, who assault passengers, pretty simple. Any crew member who sexually assaults a passenger, cruise line, or entity is strictly liable. That's just pretty much it. The passenger area has seen a lot more development and has seen a lot more interesting twists in the last few years. And you're seeing sort of an evolution and a melding of notice law for slip and falls and what we're familiar with for traditional land-based risks, if you will, coming into sexual assault law and sort of changing the landscape. And I'm going to focus a little bit on that because I think that's probably one of the more interesting and evolving areas of sexual assault maritime law. So let's talk about negligence. As everybody knows, basic garden variety negligence under general maritime law requires duty, breach, causation, damages, and in situations where the risk of harm or the risk creating condition is one that you might typically encounter on land, notice. And the 11th Circuit's sort of written its opinions for a number of years as almost 5 elements, which is interesting because you think of negligence as having only 4. And that notice element is engrafted in there. So In sexual assault negligence cases in general maritime law, the duty has evolved a bit to be, and this is really across the board for negligence, it'd be applicable to trip and fall too, but it's really coming pretty clear in the sexual assault cases that the duty is to protect from a particular injury. I should actually say assault cases as opposed to sexual, because it actually comes from a case called Fuentes we'll talk about in a minute. And the courts have begun to really focus on this idea of particular injury and specific risk. And so the notice that's required in an assault case, in a sex assault case, or just a general assault case is of the specific risk creating condition. This all flows back to the notion that, cruise ships or ship owners are not insurers of passenger safety. They owe a duty of reasonable care. And the notice that gives rise to that duty in the context of assaults, sexual or otherwise, is of the particular risk or the specific risk of harm. So in Fuentes versus Classica, which is an 11th Circuit case just a couple of years ago, the court really drilled into this. Fuentes involved a gentleman who, the day before he was assaulted by another passenger, was playing football. And as I recall, the alleged assailant had knocked the football down and made some comments about Fuentes' wife. Fuentes, according to the opinion, did not really much react to that and didn't report it to anybody. And so that was sort of the end of it. The next day, when the two passengers, Fuentes and this man, were standing in line to disembark, CBP had a problem getting everybody off, kind of slowed the line and stopped, and said about 20 or so passengers kind of backed up. And it appears that what happened is that the alleged assailant tried to cut the line. Mr. Fuentes said, "You can't cut the line, don't do that." He turned around, and pretty quickly a assault occurred in which Fuentes was hit by the assailant. There were security personnel who tried to step in between them at the time. The event was described as having occurred very, very quickly. And in the opinion, I'll look at exact language. I think they described it as having occurred like in a split second. And so when the 11th Circuit considered a summary judgment that was entered by the district court, it went into some detail about how the actual accident occurred and then what notice is required when you have a passenger who's assaulted by another passenger. And of course, this would apply to a passenger allegedly sexually assaulting another passenger. And that's where this reasoning is now gone. The 11th Circuit described it as Mr. Hadley, who was alleged to have blindsided Mr. Fuentes by punching him in the face. And in analyzing the duty that was owed, the court cited Chaparro versus Carnival, which was a duty to warn case involving a gang violence issue in St. Thomas, where a 15-year-old girl was traveling in an open jitney past an area where a gang funeral was occurring. And it was not if I remember this correctly, it was not a cruise line sponsored or purchased trip to do that, but a crew member on board a Carnival ship was alleged to have suggested she go to what's called the Cokie Beach area of St. Thomas. And so right at the moment when her jitney was going by, this open air jitney was driving by this gang funeral, the rival gang of the gang member who had been killed had appeared, gunfire erupted between the two gangs, and the 15-year-old was hit in the crossfire and killed. So it would seem like that was, sort of a pretty equally spontaneous event. And in Chaparro, which was dismissed on a motion to dismiss 12B6, the 11th Circuit reversed, sending that back, saying that enough facts had been pled to survive based on allegations that Carnival was or should have been aware of the gang violence in St. Thomas, that the risk of harm was or should have been known by them, that it was known of the gang funeral and of the gang dispute. And that when the case was reversed, Chaparro talked about the fact that the duty that was required was to protect from a particular injury. And they found that in the complaint in Chaparro, there was enough information to the effect that Carnival should have known or had constructive notice at a minimum of the risk of violence to Ms. Chaparro and Warren. In Fuentes, they cite the Chaparro a lot, and they describe what the duty is, in this case, for Classica, who was the defendant when in Mr. Fuentes' situation. So in describing the duty, they say that Classica had a duty to protect him from a particular injury. And they said that, we have held that liability under maritime law for failure to warn arises from foreseeability or knowledge that particular conduct will create danger. And they go on to say that in our circuit, this maritime standard requires that a cruise line have actual or constructive knowledge of the risk-creating condition, and Classica's duty and potential liability hinges on whether it knew or should have known of the dangerous condition. So they're taking basically all of the concepts that you see, when Sally slips on a wet spot, for example, and they're applying that to an assault case. And as they did that, they reached the conclusion that constructive notice can be established through evidence of previous similar incidents or the cruise line's prior warnings regarding the specific danger. So you hear the buzzwords, particular risk, specific danger. And so they're taking notice, and constructive notice especially, and they're really winnowing it down to you've got to have, notice of potentially of what specifically might happen. And there are cases now that are coming out that you would define the risk of harm as being whether or not a particular assailant, in this case, Mr. Hadley, was likely to commit an assault. And if there was notice of that constructive or actual, then there'd be a duty to act. So Fuentes really sort of started a trend of winnowing down. I wouldn't say started a trend, but it expanded the trend of winnowing down generalized notice of a risk of harm to a much more particular specific. And in describing, the foreseeability analysis, they really want the foreseeability to be of the specific risk. So how does one define that? In this case, is that the specific risk that passengers, when they're in this situation, you may have one who, if the situation is not well controlled, would assault another? Or is it going to be that Mr. Hadley, because of what had happened the day before and his prior interaction and so forth with Mr. Fuentes, might be predisposed to assault him? And that, I think, is where it gets very difficult in these assault cases to determine what's going to be enough in the way of notice and what's not enough in the way of notice. And so the whole area of notice, or I keep saying like a traditional slip and fall, is being engrafted into passenger assault law, and it's really causing a greater burden, as you're going to see in a moment, on a plaintiff to get past that hurdle, and I think offering a greater opportunity for a defendant to really pick at the notice and say there's just not enough specific notice of the particular risk. And that's kind of where we see a lot of evolution in sexual assault law, passenger sexual assault law negligence occurring. So this is what I was just talking about. Liability turns on notice. You don't have that, you're going to be looking at summary judgment. Prior to a case called HS versus Carnival, which we'll talk about in a minute, in Fuentes, you had a pretty broad, loose notice, maybe almost akin to what you might think of in Florida land-based negligent security. If you can show sort of a generalized risk of crime in an area, crime grids that show generally around the Shell station where a shooting occurred, that may be enough to establish notice and a duty to act. But that's not the case in maritime law. So much like we've seen over the years, the evolution of notice with respect to slip and falls and other types of land-based risks, we're seeing it here in the area of assault, and we're seeing it almost a little bit tighter, I think, in sexual assaults because of the unusual nature of sexual assaults factually and how they all differ so much. So I want to talk about HS. That was a case that we handled as a 2016 case. It was a ruling on a motion to dismiss, a 12B6 case, and it involved a young woman who went to the Club O2 lounge on board the Carnival Pride. And while she was in the Club O2 lounge, she was there with a couple of other minors, and they engaged in what is described as physical contact and or sexual activity. Now, Club O2 does not provide 24/7 monitoring. Kids are permitted to go in there. It's monitored. Sometimes it's not. It's a teen club, and the kids are permitted to leave at their free will. And so these kids did this. Apparently, there were some Club O2 personnel or employees of Carnival who were alleged to have observed it. And after they had this physical contact and sexual activity, it's important to note there was no allegation that that was not consensual. But after that occurred, and the Carnival crew member didn't do much, they left. HS went with the two other minors, and they went to another minor's cabin or stateroom, and he shared that with his 19-year-old brother. And she voluntarily went into the stateroom, and she alleges that she was sexually assaulted. The district court found that the allegations that Carnival inadequately supervised what was happening in the Club O2 lounge might be enough to survive summary judgment, but that the idea of relating that in the Club O2 lounge there was some inappropriate contact or sexual contact between minors could somehow give rise to foreseeability or a duty on the part of Carnival to prevent an assault that occurred in a separate passenger cabin was a bridge too far, and the 11th Circuit agreed. And as they talked about it, the words of the district court, and these were quoted by the 11th Circuit in the affirmance, it's a leap too far to infer that Carnival's failure to supervise and prevent minors from engaging in consensual touching and sexual activity in a public area of the ship proximately caused a subsequent sexual assault in a private area of the ship, or that the assault was foreseeable based on what Carnival should have observed. And so the court was applying kind of generally a land-based risk notice requirement to this situation and felt that it was just inadequate notice. And the district court noted at the end, HS, the plaintiff, alleged no facts to support a plausible inference that Carnival was aware of teenage boys sexually assaulting teenage girls on its vessels, or more specifically that teenage girls were leaving the youth nightclub, visiting peers' staterooms unchaperoned, and being sexually abused. I think even that statement today, had that been alleged, would be insufficient based on another case that I'll talk about in a minute called Foster. Because the evolution of the notice requirement after Fuentes is tightening and tightening and tightening, and that generalized notice does not appear to be enough. So substantial similarity takes on a really interesting meaning when we talk about sexual assaults, because it's been defined generally by the courts, recently the 11th Circuit, as meaning the accident, so let's change that to the assault, must have occurred under similar circumstances or share the same cause. So it can't be too remote in time. The conditions must be substantially similar. Well, substantially similar is really sort of the trick here when you talk about a sexual assault. Just saying there were 20 sexual assaults is not going to work. That's not going to be enough. You're going to have to drill down and get into the nitty gritty, the facts involving those sexual assaults. Were they passenger or crew? Where did they occur? Were they in, staterooms in public areas? Was alcohol involved? Was it not? Were there drugs sometimes, like a Mickey or something involved? Those are all going to be important to really getting to substantially similar. And the courts are going to reject sweeping ideas of just the sheer number of categorized prior assaults being, sexual in nature, sexual assaults. And you'll see that in just a moment. And then the third prong, of course, is no prejudice or confusion. That's just a 403. And that's fine. But the real issue is going to be, what are the specifics surrounding the nature of the priors? Because that's how the court's going to determine whether they're going to rise to the level of being predictive and being potentially usable or substantially similar for purposes of notice. So applying sort of Fuentes and HS, assault to be reasonably foreseeable. This is Fuentes. Carnival, I'm applying Fuentes. Carnival has a duty to protect against or warn of criminal attack only when Carnival could reasonably apprehend the danger such that the attack was foreseeable. So let's take and say reasonably apprehend the risk of sexual assault, such that the assault was foreseeable. And that means you're going to need specifics in your notice if there's some kind of actual notice, or more likely constructive. Foreseeability of a criminal act as to both duty and proximate cause is generally for the court to decide as a matter of law. And that's helpful to defendants because you can get summary judgment in these cases on foreseeability and on lack of notice. And the courts seem comfortable doing that generally in the notice cases. And there are cases that say that intentional torts and illegal acts of third parties are unforeseeable as a matter of law, and those are beneficial to defendants in this context. So we talked about HS already, we've talked about Fuentes, and now I want to talk about a case called Foster. Foster is on appeal right now. It's a Carnival case. The plaintiff was a minor, a passenger on board the Carnival Horizon. She was alleged she was sexually assaulted by 2 of 3 boys who she had befriended, met, spent time with. And they were in the Club 02 on board the ship. And after being in there for a while, she left Club 02. The group was talking. I've forgotten the whole story, but they walked up, got pizza, came down, and then she was walking back to her cabin, and one of the other minors said, "Hey, I need to go get my phone charger in my room. Do you mind going by there with me?" She said, "No, I can do that." So they went by, and then what happened is that once they got inside the room, she went to get a tissue, and then this other passenger shut the door, locked it, and they alleged she said she was sexually assaulted by the boys. And so the plaintiff brought suit, and Carnival produced, and the plaintiff relied upon 102 prior passenger with passenger sexual assaults. And Carnival distinguished those sexual assaults and argued to the court that none of them was similar to what occurred to Ms. Foster, not one. And what they consisted of is everything you would expect. In the summary judgment order, the court characterizes them as 102 fleet-wide reports of sexual assaults of various types on passengers. I think it's helpful to Carnival that they were fleet-wide because that Carnival has a broad fleet, so that spreads it. But still, 100 sounds like an awful lot, and it sounds like just a first blush that ought to give you constructive notice. But it doesn't, in this case, according to the district court. The sexual assaults of various types included groping, other unwanted touching, incest, incidents where a person could not recall what happened but may have been assaulted. Instances began with consent and consent was withdrawn, and incidents where the allegation was retracted. So the court really looked at the specifics of the incidents and not the sheer volume of the general characterization of there being sexual assaults. And in doing so, it held that they just weren't specific enough, and it found that made Carnival have no duty, and it made what occurred to the plaintiff to not have been foreseeable in this particular instance. In the district court summary judgment, and in discussing, I want to make sure this is Fuentes. In discussing Fuentes, the district court said the 11th Circuit appealed, noting that in determining the existence of a duty, a court must examine and weigh the probability of an accident, so we'd say assault, the potential extent of the injury, and the cost of adequate precautions. The 11th Circuit found that plaintiff's foreseeability analysis was described at too high a level of generality and ignored too many variables. So that was how the 11th Circuit described the argument in Fuentes, the broad brush foreseeability argument. And this is the sort of the way the district court applied its own logic and said, you need more specificity and fewer variables. And you're going to get to fewer variables by having priors that are actually similar in nature or substantially similar. And going on, the district court said the plaintiff's reliance on the 102 fleet-wide incident reports over the course of 3 years to establish constructive notice of the risk to plaintiff is too high a level of generality and ignores too many variables. None of the incidents are substantially similar to the occurrence in question. In determining the existence of a duty, a court must examine and weigh the probability of an accident, change that to assault, the potential extent of the injury, and the cost of adequate protection, citing Fuentes. And then it went on to say, plaintiff misses the emphasis in Fuentes on the importance of the particular facts of each case in the determination of whether a particular injury was foreseeable. And cases bring back to the 102 instances. Here, plaintiff lumps all 102 incidents into one category of, quote, sexual assault without further inquiry as to particular events that gave rise to each incident. So I think Fuentes, assuming it gets affirmed, and that's probably a big assumption, but if it gets affirmed, it's instructive, probably instructive either way, that to make out constructive notice in a passenger, on passenger, with passenger sexual assault, you're going to need more than just 100 prior passenger sexual assaults. You're going to need at least a couple that have similar facts as it relates to, what would be predictive or foreseeable, and similar facts as it relates to what might give rise to a duty. And if you don't have the particular specific facts to convince a court that they're similar, you're going to have a result like this, and you're not going to be able to go forward. For a defendant, this really does sort of raise the stakes and mean that you're going to have to go to the effort of trying to distinguish, 100 or however many it is, priors factually, and you're going to have to dig into the facts. Your defendants are always very reluctant to get into what they characterize as work product and so forth, and some of the things they need to make those distinctions, but it's going to become very important to go ahead and dig into that and get the information and share it in an effort to try to create differences through which you can suggest that these are not, the same, that they're not similar. The specifics, the devil is in the details, and they don't get you there. So, all right. That pretty much covers passengers, because passenger assaults are very much akin to any type of a land-based risk-creating condition you find at sea. There is probably room for an argument. I don't know if it'd be successful, but there's probably room for an argument for someone to make that the passenger standard of negligence is worthy of scrutiny, and that maybe there should be a sliding scale because of the unique nautical nature of the adventure and the relationship of these occurrences on ships. Now, you're going to have to sort of play around and try to find a factual hook to get into that line of cases that talks about the common carrier standard, which we all think of as being just straight negligence on a Tamarack, being a sliding scale depending upon the relationship of the risk to the nautical nature of the adventure. But I think there is room for someone in the right set of facts and in the right case to try to press that envelope a little bit with the 11th and argue that it shouldn't just be a straight negligence standard that requires notice. And maybe you get them at least to back off on how much notice or what would apply in a given situation. All right, crew members. Very simple, very straightforward. There's only one recent case you might want to read if you want to see this. There's a case called Doe versus Celebrity. It's a 2024 11th Circuit case, 394 Fed 3rd 891. I'm sorry, 2004, excuse me, 891. It kind of walks through the whole history of sexual assault law involving crew members with passengers, goes all the way back to the York versus Commodore out of New York, which held it was reasonable care. Morton v. Carnival out of the 9th Circuit, which found that it was strict liability. All the cases that have followed Morton, and it describes the public policy and the rationale behind it. And then it reaches the penultimate conclusion, which is really pretty much all one needs to hear, which is that, cruise lines, defendants, ship owners have a non-delegable duty to protect passengers from crew member assaults and safely transport cruise passengers. Simple as that. And if a crew member sexually assaults a passenger, the cruise line or the ship owner is liable, period. I defend a lot of these kinds of cases, and we often say the only defense to a sexual assault by a crew member is consent, but it's really not a defense because by definition, sexual assault is non-consensual in nature. So there isn't a whole lot to talk about as far as it relates to crew member sexual assaults. They are something that cruise lines are stuck with. There are a couple of other things to consider, though. A lot of lawyers get creative and they plead a strict liability count and then they plead a negligence count. And they spend a lot of their time digging through discovery in the negligence count in order to try to get additional discovery and information to prove their negligence count. So it's a legitimate inquiry. But also, I think to a great extent, what they're looking for is things that are likely to inflame the jury. So let's go back to our 102 priors case. If you can get 102 priors and make the case in a crew member assault on a passenger that, there are 102 priors. I mean, that shows 102 prior crew member sexual assaults. look at that, that shows as a problem, whatever cruise line needs to do better, and use that to support a negligence claim, beyond the fact that you've got your straightforward strict liability, you may inflame the jury, put an expert up there who's able to really, shellac the defendant. And that's what we see is that's a way that a lot of plaintiffs try to make their case more provocative by finding that evidence and really portraying it was not just that the strict liability books, they're negligent on top of things. You don't need it as a legal matter, but we do see that a lot. And, we see the discovery coming in on that kind of thing and so forth. In terms of consent, this is just the definition of sexual assault. And it really is pretty straightforward, contact, penis in the vulva or penis in the anus. You do have to have contact. Any penetration, no matter how slight, contact in the mouth, the penis, mouth, and the vulva, and any intentional touching through the clothing of the genitalia of anybody who's not 16 with an intent to abuse, humiliate, harass. That's sort of similar, looping back to that sexual abuse statute that I cited earlier. And consent, we do find in a lot of the cases that alcohol is involved, where passenger may have been drinking, crew member assaults them, and that's always a challenge it's a challenge for both, because it's a challenge for the defense in the sense that, there's a level of intoxication that one reaches. You probably make it similar to, or think in your mind of similar to what's legal or not legal to drive a car, where your ability to consent becomes subject to debate. You have to be of sufficient capacity to knowingly consent. So where that line gets drawn, we hire toxicologists, others hire toxicologists. We all argue about that. But you've got all these cruise lines are offering these all-you-can-drink packages, and a lot of passengers are out there drinking a lot, and that oftentimes does come into play and become a central issue on the issue of consent. The other flip side of that, though, is that the plaintiff who's had too much to drink and, is a little tipsy, whatnot, and who ends up having sex with a crew member in a scenario where one could argue it's consensual, the crew member certainly thought it was, the next morning wakes up and has, oh my God, what happened, buyer's remorse, or, whatever the situation is. A lot of those facts, while they may not be able to prove consent because of an inability to have, or a lack of capacity rather to consent, juries still tend to judge, the plaintiff who drank too much and decided to have sex with the crew member, decided in quotes. And so, I think that whole issue of consent and intoxication and drinking it plays both ways. It's not to say that the cruise line can't be strictly liable in that situation. It can, but it is to say that those facts oftentimes will diminish the damages the juries are willing to award to a plaintiff, which may hark back to why you see a lot of plaintiffs bringing the negligence cause of action, trying to get as many priors as they can, and then trying to portray the cruise line as an irresponsible corporate citizen. All right, independent contractors. This is worth talking about because this is an area of the law that is in play right now. You've got spa companies, you've got art companies, you've got all manner of independent contractors on the ships. There is no case that I'm aware of. There's one magistrate's opinion, but I think it's poorly reasoned, which specifically holds an independent contractor subject to the same strict liability standard. And I'm sorry, there may be one district case that's held that. But when you dig down on that, what you see is that the underlying core basis, and I gave you that site earlier to the 2004 case involving Celebrity, the underlying rationale for strict liability is that they're crew members. And as crew members, employees of the ship owner, they sit in a unique situation. I mean, let's not kid ourselves. The passengers are instructed at the beginning on the boat drill, that safety drill, that they're to follow the instructions of the crew, do what the crew tells you. I mean, it's almost like you're clergy or a Boy Scout leader. They're who you're supposed to do what they tell you. Well, and crew members also have unique access to the cabins, the key cards, and they are all charged with responsibility for the safety of the passengers as agents of their employer, which is the ship owner. So because of that, their status, their actions are no less the actions of the ship owner, and consequently you have the strict liability. And I'm paraphrasing not nearly as articulately as the court did, but that's the reasoning behind it. But dial fast forward to a independent contractors on Hyper-technically, yes, their employees do end up on the crew list, if you will, as crew members, but they're really not employees of the cruise line, and they're not really crew members in the traditional sense. They're employees of an independent contractor who's on board pursuant to a contract to provide services which it arguably has control over. You have a whole line of cases that let out of various situations, cruise lines, based on the independent contractor doctrine of these independent contractors, such as the spa providers, the art providers, and so forth. So there's a pretty good argument, we believe, that can be made that the law should be similar to land-based law, which is that if they're acting outside the course and scope of their employment and not for their employer's benefit, when an employee of one of these independent contractors assaults a passenger, then the independent contractor should not be liable for that. But the ship owner should be, and presumably will be, on the basis that they are in fact still a crew member, and they are in fact on the ship, and they are therefore still acting, at least to some extent, as an agent of the cruise line. So while the independent contractors, we think, may be able to get out of the cases, and again, this is a developing area of law. We actually have a case now where we're trying and testing this. We think that the cruise lines are still going to be accountable and liable in that single count strict liability, not under negligence or other theory. All right. I wasn't sure how my time was going to go, but I'm getting close, so I may speed up. Discovery. I mean, everybody here is familiar with different types of discovery. Areas that we see most common. We see the plaintiffs bring the negligence actions, try to get a little more expansive discovery. You need medical records. You need to know about any history of prior trauma. The crew members, you want their employment history. Shipboard records are things, medical investigation, policies are always of interest, reports. There's law enforcement reporting on these things as per the Cruise Line Vessel Safety and Security Act. You're going to want to make sure you get those. We're dealing with an interesting issue as to the admissibility of law enforcement reports in another case that I tried actually, where Honorable Judge Kathleen Williams refused to let in the FBI's reports, and in particular their conclusion. I argued there was a hearsay exception. They were prepared pursuant to an obligation imposed by law, and they should therefore go in. She disagreed. And that's on, well, it will be on appeal at some points. Right now, we're just still pending some final post-trial rulings. But by and large, there's certainly an argument to get law enforcement reports in, and certainly something you need to look at. The local police, the CBP, the FBI, all are going to be full of very interesting information. And then obviously on board, there's lots and lots of reports. So the CVSSA is something everybody should generally familiarize themselves with if you're going to bring a sexual assault case, a maritime sexual assault case, passenger or crew. There's a lot of interesting stuff there for you to consider and look into, and a lot of requirements. So just a couple of them real quick. Video surveillance is something that ships are required to have and to maintain in order to assist in documenting crimes and provide law enforcement with, information, copies of the videos, et cetera. But what's not required by the Act is a description of where, how many. I want to say that the Act does require that they have overboard cameras. I think that a requirement is now in place. But otherwise, they don't say, for example, all common areas or, they just don't specify. And so what you'll find is that it varies widely amongst the cruise lines. Most of the major cruise lines have started to really add a lot better and a lot more cameras, but there's still, significant differences just depending on their philosophy and when the ships are built and their investment in refitting them. As ships get refitted, they almost invariably get more CCTV. Cruise lines are required to maintain their CCTV for 7 days. So if you get one of these cases, you probably had to fire off a, preserve evidence letter pretty quick. And then if 120 days if a crime was reported. So that means if your client reported it on board the ship, may or may not meet the standard, but if they reported it on the ship and into law enforcement, then it's going to meet the standard. But there's no requirement on number or location. There's also no requirement that on board those cameras be live monitored. There's a case by Judge Cook in which she specifically found that a ship owner has no duty to real-time monitor the events. Because, obviously on those cameras, if you have a camera bank and they're being real-time monitored, you would see from time to time things that might either A, give rise to a duty to act, or B, put you on notice of something or whatever. So, but Judge Cook said, no, that's not required. There is a requirement that serious incidents be reported to law enforcement. There's a form that's used by all the cruise lines. Getting that, comparing that to other records can be interesting. They have to maintain a log and statistical data relating to alleged criminal incidents on the owner's website. That can be very interesting to pull that information and then look at that. It can, in many cases, give you, the beginnings of an argument for constructive notice. It can give you something to consider about how to frame some discovery, something to compare to other things, that kind of thing. And Coast Guard enforcement guidance. There is a requirement that you provide sexual assault victims with law enforcement contact information, free internet, a phone line. Most of the cruise lines hand out a pamphlet. It's worth your confirming that and getting that, whichever side you're on. And then medical treatment is required to be given, and that's described there. Those are all the requirements of the CBS system. So I think that is pretty much it for me. I'm happy to talk about anything or answer any questions if there are any, and I will do my best to make this PowerPoint go away now. I may need Tom.
Curtis, I think that was great. Thank you so much. You can hit stop share on your screen. There should be like a little button. There you go. We can see it again. That was that was great and good stuff to hear. I actually have a question. I'm curious because you mentioned something that I think about under how chaperone. It's traditionally we have the 4 elements of negligence that we think of, but then you have obviously the duty. Notice is somewhat subsumed within the duty element, right? So how do you believe the jury should be instructed in a maritime case? If you look at the 11th Judicial Circuit pattern builder, there's not one specific for passengers. There is one for crew, but it's a little different. So how do you think the jury should be instructed in terms of the element in this nuanced situation, and how have you seen that play out?
So if I were a plaintiff, I would like to have the notice element included into the, subsumed in the negligence instruction, because I'd rather not have it featured. I'd rather have it kind of just blended right in and as one of the aspects of duty. As a defendant, I want it as a separate freestanding instruction so that I can emphasize that and argue it to the jury. That in the absence of notice of the specific risk creating condition, there can be no liability. There can be no negligence. There's no duty, however you want to phrase that, as the defendant. From a plaintiff's point of view, I think I would rather bury it in a certain sense. And I think honestly, the case law probably supports the idea of putting it in the negligence instruction. I have to think about the phraseology to really answer you, but I think it supports putting it there, because what's happened, if you look at the 11th Circuit case, you have to go back, start, I guess, with Everett v. Carnival and come forward in your notice cases. You're going to find, I don't remember where they did it. It may have been Everett for the first time, where they actually put it in almost as a 5th element, if you will, in a case that requires notice. They almost put it in as a 5th element of negligence. And to me, I think I'd rather see it that way as a plaintiff, because I think it just kind of blends and it's going to get less attention.
Makes sense. I agree. Thanks for sharing your viewpoints.